Data Protection Act. Right, when we're talking about the Data Protection Act, what I've tried to do is to compress a whole bunch of legalese into understandable content, and a lot of it isn't very sexy, not very exciting stuff, but it is. I try to put it in such a way that, you know, the key things that will affect you or that you need to know about are borne out, because, you know, the act is quite comprehensive. It's very long. To read through that thing about 3 times in the course of it getting to where it is now. So I'm going to try to go through it and you know, simplify you know, the contents as best as possible. And we're going to talk about the rights of 2 constituents of this act, the data subjects and the data controllers. And we're going to talk about enforcement and compliance. And then finally, what businesses have to do in order to ensure that they are compliant with this new legislation. All right. Now, what I'm going to do is at varying points, I may pause and you know, allow for questions. But what I'll ask to do is, if you do have questions as we go along, just put your questions in the chat, and then we'll try to address the questions that way as well. All right, so let's get going. So what I want to do is first to put things in a context. You know, there is a lot of misunderstanding or questions about data privacy and data protection, and what's the difference between the two? Is there a difference between the two? And how does the legislation or the laws affect these 2 things? So what's the real difference between these 2 things? So privacy really speaks to authorized access to private data and how private data is used and handled. Right? Now, that is slightly different from data protection, where you're talking about securing and the functions and processes you need to put in place to secure data against attack or unauthorized access. So there is also a difference between the 2. Now, the thing about most of the laws that are passed as it relates to data protection and data privacy is that they kind of mash these 2 things together. So what they try to do is to, in as comprehensive a way as possible, speak to how you treat with private data and how you have to manage access to this data, right? So it's kind of a mashup of data privacy and protection. But it is important to know that there is a sort of difference between privacy and protection. All right. So why is this stuff important? All right. One of the things that we have to appreciate now is, as we move and have been moving into digital, we share a lot of information. We have, you know, smartphones, we have our computers, our laptops, our tablets. We share a whole lot of information about ourselves or about our companies. We also, being businesses, collect a lot of information about people. And the kind of information we collect is staggering. It is also very important to understand the value of that information. It is important to understand the value of that information because it has far-reaching effects on how you engage people in fair and legal ways, but it also has implications as to the nefarious ways in which you can engage people. So well-minded people engage with this info, but criminals also can engage in this data, and it becomes important to now know how to protect this information. So I kind of want to just give you an example here of or a couple of examples of the kind of information that you nonchalantly share. So Google, I mean, one of the most used and popular platforms out there. For a single individual, Google can have this much information, 60, almost, 65,000 searches, 100,000 emails, over 2,000 contacts, the YouTube videos you watch, the number of apps you have on your phone, your location information, and I mean everywhere that you go in a very granular fashion. The number of devices you have, if you have digital wallets, it knows about the wallets that you have. And all of this is because you're storing this stuff on devices that have information that can be sent back or monitored by these platforms. Fingerprint information, if you use Google Docs, or even if you share photos and that kind of stuff. On average, this is the kind of information an entity like Google, at minimum, for a casual user has about you. So you can see that there's a lot of information that Google may have. When you look at Facebook, Facebook has a lot of personal data. And the funny thing about it, Facebook didn't ask you or force you to give them the info, but they have it. So your personal data, messages, phone contacts, events, photos, people, talk about where they've been, what they're doing, who they're with on their timelines. Not only that, but again, location information. And a lot of this stuff is shared by you with these platforms. Now, you'd say, well, no biggie, I don't have a problem with it. But when you start to think about the power and the impact that this kind of data can have, then you have to really start to think about, okay, so well, when you become aware of this and you start to say, well, hold on, maybe I don't want them to have all of this info on me, what do I do? And this is where legislation is important. I mentioned the Google, the Facebook instance, because many of us may recall the impact that Cambridge Analytica had on the presidential elections because of information it gleaned from Facebook. And when you contemplate the fact that the outcome of an election in a country like the United States could be influenced by this kind of data, you start to now understand the importance of being able to ensure that those in custody of this information do not misuse it. All right. So some key questions about data privacy and protection come up. The CEO of Facebook was grilled heavily by Congress, and there are some really serious questions we have to ask. How has the whole idea of the internet impacted this thing called privacy? Because now what we view as privacy is privacy today in a digital age is very different from what privacy used to be in the, let us say, the analog age, right? Information was not as portable. It wasn't as free-flowing as it is now, and it will continue along that pathway. One important question I get asked many times is, do I think privacy exists in a digital age? And there are various levels to that. Generalizing, no. But in people asking that question, I say, well, we kind of have to really understand what privacy looks like in a digital age and the things that you have to do. But another thing that many people and businesses need to contemplate is the fact that there are various modalities now that are designed to get information from you. And one of those is what they call the freemium model, where if something is being offered to you for free, that means you are the product. And you being the product means your information is what is of value. And offering you something for free is an effort to get that valuable information, which is your personal information. So in a digital age, the person becomes a product because your information suddenly becomes valuable. Because if I know about you, where you are, what you like to do, then I can now tailor services to you. And that becomes very valuable to service providers. So in order to, and I mean, when you contemplate, it gets very scary because, you know, you start to see, you know, where you're being contacted by people or entities that, one, you don't know how they got your information. You've never interacted with them before, but suddenly they're sending you messages in your email or on your cell phone, and you're wondering, well, hold on, how did you get my information? And in many instances, you do not want this information. You don't want these you know, messages, and you know, until now, you had no way of treating with that. You had no recourse, and that is why the laws of this nature, data protection and privacy laws, are so important. It gives you recourse when these kinds of things happen. So with that said, let's talk about what the Data Protection Act encompasses. So when we look globally, there are many countries that have existing data protection and privacy laws. You know, North America, South America, Asia, Africa, and so on. Many countries have existing privacy and protection laws. Jamaica is one of the first in the Caribbean to have comprehensive data protection laws as well. So we're doing pretty good as far as that is concerned. So what was the purpose of the Data Protection Act? So what it was really meant to do is to provide this legislative and regulatory framework for privacy and protection of personal and sensitive personal data for the individual, all right, for you and me, you know, the citizen. And in conjunction with the Constitution and the Charter of Rights, it would provide some fundamental rights to the individual as it relates to how their information is treated across the board, whether it be public sector, government, or private sector businesses. And as such, it would fundamentally change how government and private sector would now have to treat with that info. And it became a hot topic, especially with the advent of the national identification system, where, you know, government was you know, making a serious attempt to implement a system of identifying all of its citizens in an effort to provide a different type of service. The initial NIRA, National Identification Registration Act, was challenged in court because there were some aspects that didn't meld well with some people, and a lot of it was steeped in data protection. So what we found was that the NIDS system and all legislation around it became heavily dependent on the Data Protection Act because of what it was trying to do. So just to give you a kind of history of the Data Protection Act, it was first tabled in 2017. It was approved by the House of Parliament in 2020. But then it was officially gazetted, which means the law became, or the bill became law in December 1, 2021, which was last year. And what that meant was certain aspects of the law were now in effect. One of those was the creation of the Office of the Information Commissioner. And two, it triggered the creation of regulations that would facilitate the enforcement of this particular law. So for those who are not aware, laws in Jamaica really have two components. You have the law and you have the regulation. The law gives a general description of what is supposed to happen. The regulations provide the enforcement guidelines for what the law says. So you kind of have to have both in place before somebody or some entity can do something to protect you or enforce the provisions of law, which is why, you might hear, the Road Traffic Act took so long to be, implemented, because regulations were being created and so on. So you have two components. Now, with that said, when the act was gazetted in December 1, within the law, there was a 2-year transition period that would allow for a couple of things. One, it would allow for regulations to be drafted and the process of regulations to go through its consultations and so on. But two, it would allow for businesses to start their process of becoming compliant, because the law tells you everything that you need to become compliant. The regulations gives the ICO the power to enforce. So within the ambit of the law, you have a 2-year transition period, which means December 1, 2023, the Data Protection Act comes into full effect. And if you're not compliant, you'll be subject to the enforcement regulations. So while we go through the discussion, I kind of want to do some, run through some definitions with you. So within the law, certain things are defined. Data is defined. Information which is intended to be processed by equipment operating automatically is a part of, or intended to be part of, a filing system and so on, forms part of an accessible record, or is recorded information held by a public authority. That is what generally data is defined by. So this kind of covers a wide cross-section of information. Bear in mind, the law specifically talks about manual filing systems. So this does not only apply to digital information. So information in filing cabinet, which is paper, considered data. Then the act speaks to two main constituents: a data control and a data subject. Now, the data subject, simply put, is you and me. It is an identifiable individual who is subject of personal data. So that's you and me. Then you have the data controller. And the data controller can be either a person or an entity who processes or stores personal data of a data subject. All right. And this law speaks to the relationship between a data subject and a data controller. Another important constituent outlined in the Act is a thing called a data protection officer. And we'll speak about that a little later on. But the data protection officer is that individual that is supposed to ensure that your business or you are compliant with the provisions in the law. It also speaks and is very specific about personal data and processing of data. And we'll kind of get into that in a little bit. But there is a particular component in the law also that speaks to a difference between general personal data and then what they call sensitive personal data. And the law contemplates what is just general personal data and sensitive personal data. And sensitive personal data speaks to like biometric info, your, political opinions, philosophies, your, affiliations and that kind of stuff. So there is a difference between just general personal data and sensitive personal data. And there's a reason behind the separation of these two. In fact, a lot of it plays into how information about individuals is collected and why people want some collected but not other information collected. All right. So who does this law apply to? No, this is very important, especially for businesses to understand. The law is applicable to the processing of data by data controllers who are established in Jamaica or anywhere that Jamaican law is applicable by virtue of international public law, right? So you may have countries that speak to laws that apply to them based on agreements they have with other countries. That's what that means. So the European Union's data protection regulations, the GDPR, that speaks to protection of citizen data for EU citizens wherever they are and wherever that data is held. And that is manifested in the fact that there are, global agreements between countries, but once you have or are in custody of information for somebody who is in the EU, then that law applies to you. Similar thing here. It is also applicable to the processing of data by data controllers not established in Jamaica, but who use equipment located in Jamaica to process that data. Now, this is an interesting construct, because you have companies that are not registered here, but they have operations here. And what this is saying is that even if you're not registered here, if you have operations or equipment that is processing information about citizens and so on, that is physically located in Jamaica, this law applies to you. In fact, if you have equipment located in Jamaica and information is processed or passes through that equipment, it doesn't necessarily have to reside on the equipment in Jamaica, but it may pass through switches, servers, that kind of stuff, where data is in transit through Jamaica, the law applies to you, right? So that is something to be very important to bear in mind. So because of that, it was necessary in the law to define what established in Jamaica meant. So under the law, if you're incorporated or resident under the laws of Jamaica, and most companies are, the law applies to you. And as such, the appointment of necessary individuals like a data protection officer and that sort of stuff would then apply to you. So once you have any sort of operation going on in Jamaica that is processing data of Jamaican citizens, this law applies to you.
I want to say something quick there a sec. One sec, don't mean to stop you.
Mm-hmm.
Folks, some of you might be wondering and sitting down here wondering, but this sounds like only a big company act or something that only big, large companies need to worry about.
No.
Well, no, it actually goes and drills down to as far as the barber shop.
The
hairdresser.
Yes, indeed.
This is for everyone who runs a business, who collects any data on anyone. A small doctor's office, a pharmacy, a hairdresser. So I don't want some of you to be thinking, but this sounds like this is only for Grace Kennedy and so on. It's not. This goes down to even a sole trader who keeps just a name and address of somebody who he delivers goods to. I want to make that be clear.
Right. And as long as you are a business registered and established in Jamaica, this thing applies to you. Doesn't matter how small or how big you are. So that's a very important point there, Robert, because a lot of times you're correct. Many small entities do not feel that this applies to them. No, you could not be. Trust me, this thing applies to every business, no matter what the size is. So, what I want to speak to now is they're what they call, the 8 standards for processing data. And again, the legislations, gives these general standards so that people know and companies know generally how and what they must do as it relates to processing data. So there are 8 standards. First one is data must be processed fairly and lawfully. Right. The second one is data must be obtained for one or more specified and lawful purposes. What does that mean? Well, you can only seek to obtain data to do things that are legal. So you can't go ask people for data to do illegal activities. Right. So that's generally what it is saying. Data must be adequate, relevant, and not excessive in relation to the purpose for which they are processed. So what it's saying here is you ought not to ask people for more information than you need to provide the service that they're asking for. So if you are asking somebody, or if somebody is coming to you for a service, let's say hairdresser. Hairdresser don't need to know where you live, so they don't need to ask you for your address to provide that service. However, you may go to a financial institution or an insurance company. You may go to a restaurant. In creating these standards, it gives you the ability to know and to decide what information you feel is important to provide to get a service. All right, so that's really saying that, look, they may want to ask you for a lot of information, but if that information is not important or relevant to provide the service, then you don't really have to give it to get the service. Data must be accurate and where necessary kept up to date, and that is a symbiotic relationship between both the data control and the data subject. Data must be processed in accordance with the rights of data subjects as established under the Act. So what it's saying is the Act has provisions about how data must be treated with, and as such, to be in compliance with this Act, you must process the data according to the compliance measures and guidelines outlined. Data must be safeguarded against unauthorized or unlawful processing, accidental loss, destruction, or damage. Now, this speaks to a whole, and it's a very big one, because what this speaks to is what businesses must do, both from a policy and legal standpoint to protect data, but also from a technical and technology standpoint. Processes, policies that you must implement for your systems. Something as basic as making sure that your devices are kept up to date. You have antivirus, all of these things. This plays into safeguarding unauthorized and unlawful processing, accidental loss, destruction, or damage. Backups, on-site, off-site, all of these things come into this processing standard. So what you are now having to contemplate is, by law, you must have backups, right? To be compliant. You have many companies that are functioning and all, they're really not doing backups. And so now the law requires that you have those things. And it is important to have, because as you'll find later on, if an audit is done and you can't demonstrate that you have all of the measures in place to be in compliance with the standards and the law, you'll be in problems. Data must not be kept for longer than is necessary for the purpose of providing a particular service. So what I'm saying is, I don't need to have, as a business, the data for individuals longer than is necessary for the time that I'm providing a particular service to them. Now, this varies depending on the type of businesses. Health records have a particular amount of time that they must be kept for. But if it is that I need to provide a particular piece of information to get a particular service, and once I get the service, you don't need that information anymore, that information must be destroyed. So that's what this particular standard is meant to say. The last one, which this was the subject of much discussion during the Joint Select Committee, data must not be transferred to a state or territory outside of Jamaica unless that jurisdiction has adequate or similar levels of data protection laws and rights and freedoms and so on for data subjects. So what that means is, and this is a question that comes up a lot. Well, suppose I use, and in this day and age, cloud services. you know, for whatever reason, it makes business sense and so on. Will the data protection act mean that, you know, I can't have data stored abroad? What this standard is saying is that you can, but one, you must ensure that the jurisdiction or the physical location of that data is in a jurisdiction that has laws similar to ours. All right, so that's the first thing. The second thing is you will have to ensure that the way in which the whatever service provider stores that info is in compliance with our laws. So for those who question whether or not, you know, they can now continue to use cloud services and so on, yes, you can. But now you have a duty of care to ensure that you know physically where the data is stored and also how your service provider is treating with that information. All right. Another thing to point out is within the law, it says there are certain types of data that cannot be stored outside of Jamaica. And you know, we'll speak a little bit to that. So these 8 standards kind of summarize the meat of how businesses and the responsibilities you have for treating with personal data. All right, so as with all laws, there are always exceptions to those standards. And what I've listed here is a couple of the exceptions. Now, the thing about our exemptions, and the thing about it is, even though these are exemptions, entities that fall within the umbrella of these exemptions still have to comply with the law for the exemptions to come into effect, right? So the fact that they're exemptions does not mean that they cannot or are you know, given a free ride as to compliance. They must be compliant, but in certain instances, there are provisions in the law that they would be exempt. So national security, you know, police, JDF, so on, the tax authorities, health, you know, the health sector, education, you know, regulators, journalists, researchers, and so on. All of these, they're within the Act, there are provisions for exemptions as it relates to these different disciplines and so on. So what you may find is, whereas the law may state that, you must provide this kind of information, or you don't have to provide this kind of information, it really depends on the nature of who is asking for it and what will be done with it and so on. All right. So there, it's important to know that there are some exemptions in the law, and it's very prescriptive as to how these exemptions work. All right. Now, with the creation of these standards and the, you know, attendant exemptions and so on, it became necessary to establish, you know, an entity that would provide oversight to ensure that all the players are in compliance with this piece of legislation. And that compliance agency is called the Office of the Information Commissioner, and that office acts as the data protection regulator. It is a creature of Parliament, so it reports to Parliament, much like the what's it called, Indicom and Contractor General. And the purpose of the Office of the Information Commissioner is to monitor compliance with the Act and its regulations, advise the portfolio minister, which should be the believe the Minister of Technology, disseminate info, so educate the public as to rights and obligations and so on. But it also, and you know, we say monitoring and compliance, monitor compliance. This office has the ability to come in and do audits on any business. right? It has the power invested in it to shut a business down if it finds that that business is not compliant with the law. And I mean, seriously, it can do that. So if someone makes a complaint to the Office of the Information Commissioner, and that office is prompted to do an audit on your business, and you're found to be non-compliant, they can shut your business down until you become compliant. And it has full power to do that. And guess what? Doesn't need to go to court to do it. All right. So the law gives it that kind of power to do that kind of thing. Now, the thing about it is the Information Commissioner can take, complaints from data subjects. So if you as a data subject don't feel that your information is being treated with, you complain to the Information Commissioner. If they find, just cause to go and audit an entity, they can do so on your behalf and ensure that entities or people in custody of your personal info are treating with it in the right way. All right, so I'm going to pause here and let me just check the chat to see if there are any questions thus far. If not, let me just ask if there's anyone who has any questions thus far before I move on to the rights and duties of the data subjects and controllers.
I have a question, Trevor.
Yes, go ahead.
Okay, you mentioned that about the jurisdiction of Jamaica. If the law I wanted to know if the law applies when you have a contract that specifically states that in other words, if there are any conflicts with the contract, if any court appearances have to happen, that it must happen within the jurisdiction of Jamaica. Would the law apply in that case to the contract? And also in terms of the address information, wouldn't we need, or is it okay to have that information if you're doing business that involves invoices and contracts? That's
All right, let me answer the last one first because that's easier. The address information for an invoice, not so much. It's more what is outlined in the contract. So now it's important to ensure that, that first clause in your contract where it says who the contract is between, it's now important to have the name of the company established in.
Okay.
So now, before you just have the names of the two companies. Now you have to have names of the companies established in. That's very important now. But then there's another section where there's applicability of the law in most contracts. And there you'd have to say whatever is in that contract is subject to the laws of Jamaica.
Okay.
Right. So again, you have to put that in there because that will then imply that whatever law prevails in Jamaica would apply to those in the contract.
Or just to get back to the address. No. Sorry. Continue.
So what that no requires, because you do have some contracts that get very complex, is now you need to have your lawyers review all of your contractual arrangements to ensure that whatever compliance issues prevail with this particular piece of legislation, especially as a service provider, that you are now in step with that. Right. So like for me, I don't push out contracts now, even the ones that were pre-created, until I have my lawyer review them, because we need to make sure that all clauses and requirements would make us in compliance with the legislation. Because bear in mind, you may have contracts with people who are entities who, and I speak to it in a little while, who process data for you. You don't process the data, but they process the data for you. Well, the thing about it is the Data Protection Act for Jamaica does not put any responsibility on a data processor.
Ooh.
Right? What it does is it says the data controller must ensure that any third party it has dealings with is in compliance with this act. So it is the responsibility of the data controller, not the processor, to be in compliance. So what you find is that there are many, especially financial institutions, because we've been subject to these requirements because of the clients that we have. They will put you through a process because you're providing a processing service to them that affects their customers. Their customers don't know about us. Their customers just knows about the financial institution. But there's a responsibility by law of the financial institution to ensure that our operations are in compliance with the law that affects them. So they have to now put us through a process that shows that we are compliant with the law, and it is their responsibility to do so. So let's say you're using Amazon, right, to do something. It is necessary for you to ensure that Amazon is in compliance, which these companies typically are, with the laws here. Let's put one more wrinkle in that. You have contracted a company, and that company uses Amazon for processing of data. You have to make sure that that company that you have contracted is in compliance with what the law says. That company may be in Jamaica or maybe out of Jamaica, but you have to make sure that they are in compliance with the law, because if something happens that threatens the security of the data that third party has on the Jamaican citizen, they're not the ones who are going to be held responsible. You are.
Okay.
Because you are the ones who are the law applies to the controller.
Okay, understood. Thank you.
Are there any other questions? Going once, going twice. All right, so what I'm going to do now is speak to the duties and the rights of the two main characters in this legislative framework, the data subject and the data controller. So the data subject, as I said before, that's us. The people who the data is the subject of. So there are a couple of rights that the data subject has. You have the right to be informed by the data controller whether the data is being processed by them or on behalf of them. So again, I recall many moons ago, I called a service provider with a complaint, and their response to me is, well, we don't really process that info. We have a company that does that, so we'd have to speak to them. I'm like, hold on, wait a second. I didn't tell you you could do that, but at the time there were no laws to prevent that. And they were not obliged to tell me. Now they are. So if a company is using another entity to process your data, they have to tell you. In fact, they have to tell you what data is being processed. All right. So if you want to know what is being processed or what information is being processed about you, you now have the right to know. You have the right to complain to the Information Commissioner if you feel that your data is not being processed in accordance with the law. So if it is that you have never gone to Singer before in your life, but suddenly you get a message on your phone from Singer saying, hey, we have these new deals that we want to send to you. And so you're like, hold on a second. I've never, ever gone to Singer, nor have I provided them with my info. Now you're going to start questioning, well, how did Singer get my info? And you can do one or two things. You can either look back at all the other entities that you provide your info to, or you can say, Singer, how did you get my information? And if they don't want to give you, you can go to the Information Commission and say, Singer has my information, but they never got it from me, and I never gave it to them, but they're communicating to me with it. Please check that out, because I don't know what they're doing with my info, and I don't know how they get it. That's what the law facilitates. You get interesting messages from Flow, Digicel, all sorts of entities that you may not know or want information for. Now you have the right to say, one, don't send me nothing. Two, how did you get my info? And they're obliged to tell you. And well, I don't want you to have my info anymore, so please delete it. You have the right to do that, right? Many times, and this last one here, informed of the logic involved in a decision where the processing is by automatic means for the purpose of evaluation matters. All right. This one, wholly for discussion when the law was being created for this, because of the word logic. So, but what this means is, let's say you apply for a loan at a financial institution, and through an automated process, you're not approved for the loan. Let's just say that, right? One of the things that you can query is, how did they use the information you provided to them? Now, that has some limitations, as outlined in some of the exemptions there, but you have the ability to query how your data was being used. Why? Because they may send it to somebody else for processing, which they have to tell you about. And if they never told you, that's a problem. So whenever you have an issue with any aspect of how your data is being treated as a subject, you have recourse, and your recourse is to contact the Information Commissioner and say, listen, I want to go check this thing out because I don't like how they're dealing with my stuff, right? You also have the right to opt out of data collection exercises. And a lot of this, again, came from the, where information was being queried about needs and so on, and all of that, right? So you do have the right to opt out. You will notice in the new needs legislation, it is a voluntary activity. It is no longer something that could be viewed as a criminal offense if you don't participate. But you do have the option to say, listen, I don't want to participate. Now, what that means for controllers is that if you're collecting information about somebody, you now must provide an opt-in or opt-out option on any forms that you're providing, both during or at the time of collection and after. So even if you collected information about somebody, then you send communications to them. Part of that exercise must include the option for people to say, please do not send me any more information, right? So opt-outs and of course opt-ins are now mandatory. You must provide the option to anybody who you're communicating with and so on. You can opt out for a number of reasons. If you feel the information is not accurate, and of course one of the rights you have is to ensure that your information is accurate, and the controller must see to that. And of course you see here, and again, this was a big one.
Excuse me, Trevor, sorry to interrupt. There's a question from Marcia
yes,
M. When you're finished. Okay.
I saw the question, which is why I'm getting to this particular one.
Okay.
Where it says you can opt out if data is being processed for purpose of direct marketing, example, advertising, marketing material, and so on. And we find that a lot of businesses do this. And one of the things that because I saw questions where will the rights be applicable retroactively? And I want to explain how that works. So what happens is, one, there is a 2-year period to become compliant. Many of these entities, and the entity referencing this question of, say, Digicel, they may have collected your information before. In fact, they may be using your information, and they may have sent their information to their different agencies and so on to communicate with you. What they must do now, and all of their different arms and so on, is provide you the option to tell them, don't use my data anymore, right? So what happens over time is that once you get communications, part of that communication must have the option for you to immediately say, don't send me anything anymore. So if they had 10 agencies and all 10 agencies are communicating with you differently, all 10 of them must now provide you the option of saying, don't send me anything, remove my data, right? So even if they gave your data to somebody else or sold it to somebody else, when those people are communicating with you, or if they ever communicate with you and you find out, or you have reason to believe that an entity that you did not give your information to has your data, one, they have to provide the option to tell them to remove it. You have that right. And if they don't do that, you can go to the Information Commissioner and say, please go and interrogate these people because they have my information. I didn't give it to them and I don't like how they treated with it. So it's not retroactively applied in the traditional sense, but what happens is over time, the effect of them giving your information to somebody else will now be mitigated by the fact that whoever uses it has to allow you to tell them not to use it and to delete it. But two, if you find out that somebody has your information and you didn't give it to them, you can then say, go and investigate these people because one, I didn't give them my information. Two, they have not given me the option to tell them, delete it. Three, I don't like how they're treating with it. So that's how it kind of treats with that. Now, there is something that you must be aware of as a data subject. If you go and take your data and put it out a road, put it in the public domain, you can't prevent that data from being processed. All right. So when you go on Facebook and you put all of your information on Facebook, it does not prevent one Facebook, but also other entities from capturing and processing that data. So be mindful of that. However, even if they go and they get that data and they start to use it, your recourse is to say, yeah, I don't want to use my data, please delete it, or they must provide you the ability to opt out of how they're using that data, right? So be mindful of the fact that if you put it public and they went and got it, you can't stop them from processing it that way. But you know, this is how the act works in a cyclical sense. Once you determine that somebody that you didn't explicitly give your data to is processing your data, then you can take an action. All right. That's how the law protects you. Now, there are instances where you may have information that is stored by different entities. It is your duty as a data subject to ensure that the data that they have is correct. You must notify the data controller that may have the information. So, you know, where banks are required to do, you know your customer and updates of customer information and so on, that is a responsibility placed on them by another law, but other people or entities that may not be subject to those laws may have information about you that they take decisions about. It is up to you as a data subject to ensure that the information they have is correct. In doing so, data controllers now must provide a mechanism. So it's not only banks now have to do this. Everybody who is a data controller has to now provide a mechanism for the people whose information they have to ensure that the information is correct. So they have to provide a rectification mechanism for that, right? So that is something that, because the data subject has the right to ensure that the information that is stored about them is correct, the controller must provide a method for the subject to do that. All right.
Question, Trevor.
Yeah.
The subject has to be an individual, or the subject can be a company?
Can be an individual or company.
So when a company, or let us use
it's primarily individual, but it can be a company. And here's the reason why. A company can be an individual.
Okay. So the question here, I beg to ask the question here now then. Say, you know, these blogs or blasts that go out to companies. So say even for this, now I want to send out that I am hosting something else or having a special on something for this month. And I have a list that I have compiled either in my office from before, or I get it from social media and so on, and shoot that information out to my customers and companies and individuals too. How is that now a breach? Do I have permission before? How?
No. So what you're required to do now to be compliant is whatever platform you use to email it out, which means now you're going to have to use platforms to do this, must have as part of the message what they call an opt-out button. And what that button does is it says
unsubscribe or
right, absolutely. So what that does is it gives the receiver the option to say, please don't send me any of this stuff anymore and remove me from your database. Right? So you'll start to see now that sending an email blast via your regular email client or your mailbox may not be a good idea these days, because you will now have to manage the responses you get back from people manually, saying, please don't send me anything more. So what you typically would do is you would use platforms like Constant Contact, MailChimp, MailerSend, those kinds of things that by using them, they require that you put those things in the messages that you send out. But what happens is those platforms will automatically manage opt-out requests. So you don't have to manage them yourself. But you are in breach if you do not provide that option.
Okay.
Right? Because if you don't provide that option and the person then queries or questions where you got their information from, they can go to the Information Commissioner and say, hey, go check out them people and find out why them sending me this stuff. If you get audited and can't demonstrate that you had sufficient processes in place to be in compliance with the law, which means duty of care of the personal information and also providing the subject with an option to tell you, don't send me or get rid of my info, then you'd be in breach. All right. Right. So and we're getting to that here with the duties and rights of the data controllers, because there are some responsibilities on the data controllers. And ladies and gentlemen, let me tell you, like I said at the beginning, this stuff not sexy, right? But I'm trying to condense all of this stuff that was in the act, because like I said, the act is very comprehensive. It's an interesting read. But I'm trying to compress a lot of information into a couple of slides here. So data controllers, they have some obligations and some rights as well. The key one is, as a data controller, you must be registered. So if you are treating with people's information and data, you have to register with the Office of the Information Commissioner will have a register. If you do not register, you have a problem.
Hold on, stick a pin. So you're saying no, for all of us who are here, because pretty much everybody in here is a controller, they are controlling some people's data. We have to, there's another registration to do now, apart from company registration, apart from tax registration, we have to go and register now again in another body?
Yes.
All right, folks, you're hearing that?
Yes. And I've provided just some basic information as to what the registration requirements are. Name, address, contact information for the data controller, as well as the information for the data protection officer. So the regulator, which is the Office of the Information Commissioner, will require that you register with them. And the information that you must provide is the contact info for your business, the data controller, the name of your data protection officer, and I'll get into that information in a little bit as to what the data protection officer is. You must also give a description of the data that you're processing, why you're processing it, and who you're processing it for or on behalf of, etc. If you are processing information using jurisdictions outside of Jamaica, you have to speak to that as well. And you have to state whether or not you're a public or a private entity, right? So these are some of the basic things that must be provided. Now, I'm sure the Office of Information Commissioner will provide a very easy portal for this to happen, but this is something you're going to be required to do if it is that you're processing data. First big one.
I hope this is not something that they're going to go and charge fees on again to do.
No, no, this is not a fee-based exercise.
Okay.
Yeah. The second thing that is important is that data controllers must appoint what's called a data protection officer. And the data protection officer's role is to ensure that the controller is in compliance with the provisions of the law. Ensure that the controller processes data in compliance, make sure it acts as a conduit between the information commissioner and the data controller, to ensure that you know, if a data subject request comes in, that it is handled appropriately and so on. Now, the thing about the data protection officer, and when you read the act, you might immediately feel that, oh, here is a new staff member I have to appoint. This is not so. You can have an in-house data protection officer appropriately qualified, or you can outsource it. So when the law says you must appoint a data protection officer, you can actually, because there are companies that do that, you can actually appoint a data protection officer. It must be the same way you appoint a company secretary. It can be internal or it can be external. All right. But you must appoint one, because part of your registration as a data controller is that provide the information for your data protection officer. All right. So that's the second big one. All right. Now we move on to sharing of data. Now, invariably, you may find that in the normal course of business, you may have to share information about your customers for whatever reason. In order to do that, you must gain consent to do this from the subject before you can transfer or send that information. There are various ways you can do that. One of the quickest ways to do that is to have it in any service contract or service level agreement that you have with any of your customers. So again, you have to review your contractual agreements and service level agreements with your clients to perhaps state in there that they are consenting to you providing their data to someone else. One of the things, again, that must happen is when you do that, you must have a process in place that allows you to, one, inform as needed, but also to demonstrate that you have that process in place in case of an audit, right? So you have to get that consent. The entity that you may be sharing that information with, you as the data controller must ensure that that entity, before you share the information with them, has similar measures in place that make them compliant with the data protection law. All right. So you see now that the third party and how they treat the information becomes your responsibility, because ultimately you as the controller are held responsible for what that third party does. So you now have to put measures in place to make sure that that is sorted out. That now speaks to the contractual arrangements you have with third parties, and here you will see, and I think Sylvia, you were alluding to something like this. These contracts have to be revised now to ensure and reviewed to ensure that, one, who you're sharing information with, whether they're in Jamaica or outside of Jamaica, they are compliant with the Data Protection Act. Also, if they're outside of Jamaica, they must be in a jurisdiction that has similar type laws as we have here, so that they can be compliant. If not, you have to go and again, that's why I showed you the map of, you know, places that have data protection legislation. If they are not compliant or not in a jurisdiction that is compliant, you can't use them, because that becomes a risk to you. Because the law does not put any onus on the third party processor. It puts it on the controller.
That's a serious implication there, though, Trevor, because the US does not have the same data protection laws as Europe and Jamaica. We do a lot of business in registering contracts and deals for customers. So I like giving real life examples. So we are doing a bid for the government or a bid for a customer. And to do the bid, we have to register it with our overseas vendors so we can get special pricing on it. We have to give the vendor, the customer's name, address, TRN number, this kind of information to them. So it's registered that this customer is doing this for this particular bid. But the US data protection laws are a bit different from ours.
Yes.
Are you saying no, that I cannot do that?
No, because the law speaks to the fact that you, and let me see if I have the wording here, that it says a couple of things. One, it says that if you're doing it in a jurisdiction outside of Jamaica, that jurisdiction must have laws similar that provide similar provisions for the protection of data, right? Protection of personal data. Now, the thing with the US, and you use the US specifically, the US doesn't have a single law that does that. There's more than one, but it is angling to have a comprehensive law to do that, but it does not have a single law, right? So that's the first consideration. It has about 2 or 3. So like in health sector, them have HIPAA, then them have Sarbanes-Oxley, and then them have, you know, it's a jumble of legislations, but generally they have laws that speak to protection of personal info, albeit perhaps not as comprehensive as ours, but they do. But here's the other thing. Most times the companies that you're dealing with, so like say you're dealing with a Cisco, right? Cisco is a global company, which means the GDPR, which is coming out of the EU, applies to them, and they have to be in compliance with that. And because they're in compliance with that, when you deal with them as a company, and our act is heavily fashioned off of the GDPR, because you're dealing with them as a company, you can almost be assured that they would be in compliance because they need to have processors who employ sufficient technical and organizational practices and measures in compliance with the laws you see there. So those are some of the considerations that you have to make. So the entities that you engage with, while they may be in a jurisdiction that doesn't have word for word the kind of laws that we have, they generally might have, but themselves are in countries that require them to be in compliance with their laws, which look like ours. And that is how it works.
That go for any one of our customers who order products from overseas then.
Sorry, say again?
And that would go for any one of our customers who order products from overseas then.
It's possible, yes.
Wow. So
that's why I say this is a very far-reaching and high implication piece of legislation, right? That's why we were, that's why we try to speak so much about it, because I don't think a lot of companies understand the far-reaching implications of this thing. And this is a global thing, because when GDPR came into effect, you may recall many companies started to feel when it got enforced. Right, so it's important for you to understand some of these finer details, because the question you asked is very good, because you may feel that, oh, some things you can't do anymore, but no, there are conduits that allow you to still continue, because the law doesn't want to be a hindrance, but you have to understand how it works so that you can protect yourself when you are doing business with other entities. Because there are some entities that, because of their jurisdiction and because of their laws, you can't do business with them. You will not be able to do business with them. Wow. But you have to be aware of how that particular entity and their jurisdiction plays into, this particular piece of legislation.
So with that same kind of paradigm that you're speaking about there, let us put it locally. We are doing business, or one of our customers doing business, one of our customers now do business with other vendors, but the other vendors are not compliant with their data that they are giving to them. How does that affect now? Like doing real world situations. So one of my customers now, they send out contracts to different people to get jobs done. All right. But a number of people that they send out these jobs to get done now are now fall that they really have none of this in place in dealing with that kind of stuff. How does that affect them now doing business with that person who does not have these things put in place?
The same way, they have to ensure that whoever they're sharing data with is compliant.
Wow.
Yeah, that's right.
Everybody listen.
And through that cycle, the idea is that if you want to do business with me, you have to be compliant, and vice versa. So over through that regime, the idea is that you will ultimately have overall compliance.
So I come to the individual tradesman now who is doing his thing now. He may be a woodworkman or so on that you hire every now and then to do a job for you.
Yeah.
He has your name and address on something that he sends an invoice to you for after he's done his work, but he doesn't have any of these things put in place. What happens to him? Are you saying I cannot do business with him anymore?
No. What I'm saying is you and him need to be clear that, one, he, as somebody that has your information, needs to go and register. You need to impress upon him that he should go and register, because if he doesn't do that, he will be in trouble. It's up to you if you want to keep sending information to him. But woe be to him if somebody complains that he has their information and he gets audited because somebody complained to the information commissioner. People can always fly under the radar, but the day that somebody launches a complaint and audit is done, you have a problem. It's as simple as that.
But all right.
Just, I want to ask a question.
Go ahead, Sir Blackwood.
And I realized that he partially answered what I was about to ask about the whole monitoring and enforcement of.
Well, I'm actually going to get to the enforcement and monitoring part. So but go ahead, ask the question.
Yeah, because I just see that based on the really omnibus nature of this and how comprehensive and far-reaching it is, monitoring is going to probably as greater challenge than as any other act in Jamaica to be enforced.
Absolutely.
Because
this one more so than many of the others.
So, and I'm going to listen to you, but I really realize that while it's going to have serious implications, as you said, if you are audited and found to be wanting and so on, yes. But it's not going to be one of those that is going to be easily monitored at all.
Well, I'm going to actually, it might not be as bad as you think, because I'm going to tell you some of the things that you can do, because there are platforms that allow you to monitor these things in a very efficient way. It seems onerous right now because you're hearing this stuff and you're like, oh my God, how am I going to do this? Remember, this is being done all over the world. The thing about it is, and that's why they give a 2-year ramp up time so that businesses would be able to implement what is needed to get to the point where they can monitor and manage compliance. Because they could never have done this and say it comes into effect today and people immediately be out of compliance, right? That's why they gave the window, right? So and let me continue, and you will see some of these things that I'm speaking about. So here, like I said, you have to ensure that the third parties that they're dealing with, they are in compliance and are treating properly with the data that they have for you and for your clients. Okay, another big one is what happens when data is breached. It's a big one. No, it's important to remember this. In the digital age, and it's something I constantly speak to whenever I speak about cybersecurity events and so on. Breaches are going to happen. When you're in the digital age, you're not going to be able to stop it. It is a fact of life, right? So get used to it, right? You can't stop these motivated digital criminals. You can mitigate as best as possible, but breaches are going to occur because there are inherent things that you have no control over that will cause these things to happen. As such, whenever a breach occurs, and it's the first time this has happened in Jamaica, this has been and for you, Robert, like in the United States, this has been something that's been around for a very long time. Whenever a breach occurs, you must be notified, one, as a subject and also the information commissioner. And the law speaks to when this should happen. So the data controller is required to report any security breach to the information commissioner within 72 hours of becoming aware of it. That information, you must provide a whole host of information. Facts around the breach, description of what was breached, measures taken to mitigate the breach, and what the fallout may be. Similarly, and this is what is new, because a whole heap of institutions go around this one. Whenever you have a breach, the subject must be notified that the breach occurred. Now, you would appreciate that there are many businesses that skirt around this, especially in the financial institution realm, right? Because of a variety of things. But now the law will require that you be notified whenever a breach occurs. And that's going to be interesting because all of the breaches that the public don't know about, they're going to have to know about them now. That puts the onus on the controller to ensure that you have systems in place and processes in place to treat with these occurrences. And this is why I often say again, don't try to hide the fact that a breach occurred. Try to speak more to the measures you have in place to mitigate the fallout. Because trust me, you can't do nothing to stop a data breach. What you can do is instill confidence and trust in your customer that you are doing as much as possible to mitigate what has happened, the fallout, and what will happen in future, right? Well, this law is saying, yeah, when it happens, if you don't report it, you will not be in compliance with the law, and that will have its own consequences, as you'll see in the compliance part of this presentation, which I will touch on next. All right, and I'm gonna speed it up a little bit because I know time, we don't have a lot of time left. So, and I think this part again, on top of registration, is an important aspect, which is why I bolded it for businesses and data controllers. To be in compliance, you not only have to register, but every year you have to submit a data protection impact assessment to the Office of the Information Commissioner. All right, so now you start to say, well, mom and pop shop or hairdresser, barber, you know, the single person. How are they going to do this? Impact assessments come in different forms because the size or type of business informs the depth of an impact assessment. But the idea is you need to submit one every year. Now, this may be an impact assessment that is repetitive because your business hasn't changed. But what may happen is the amount of data you're in custody of has changed. But again, I believe the Office of the Commissioner will provide a form and a portal for you to submit this, which is really filling out a form and answering some questions. But this is a very important thing because there are consequences if you don't do this. Assessment notices may be served for the purpose of enabling Commission to determine if a data controller is compliant. So what this means is the Office of the Information Commissioner can just tell you, say, listen, we're going to come check to make sure that you're in compliance. Prepare for us because we need to check to make sure that and they can do that at will anytime. Right, I'm just going to give you a notice and you have to prepare yourself for an audit. If somebody believes that their data is not being processed properly, they can complain to the commissioner, and the commissioner is obliged to go and run an audit on who they're complaining about. Anyone who fails to comply with an enforcement, assessment, or information notice commits an offense, and that has consequences. Any person, when they say person, they use person to mean individual or company, who has been served on information enforcement or assessment notice has the right to appeal, right? Now, remember I said the commissioner doesn't have to go to court to get the note, to get permission to come in and audit you. But the law says you can appeal, which means you can take that to court, your appeal, and you know that can be ferreted out in court. But the Information Commission does not need to go to court to get cause and reason to come and audit. All right. So that speaks to that. Now, the controller does have the right to refuse a request. There are specific cases for that. You may ask the controller, or the controller may be asked by the a subject or the commissioner for information. The controller may say, well, hold on, I can't, depending on the nature of the business, I can't provide you that until you provide me some more details. So you have the ability to say, so hold on, I can't do that right now until you provide some other information. It also has contemplates a scenario where by providing requested information, you may then compromise information about somebody else. Now, this one has an interesting background because you will notice in the exemptions, journalism was an exemption. And one of the things that was an issue with the Media Association when they came to Joint Select was the fact that because they may write stories and reference sources, if a company was the subject of an article and the company says, well, I want you to tell through the information commissioner, investigate and see where they got that information from about my company, because they really shouldn't have it. It actually provided a component or contemplation for protection of sources. So this is kind of where some of that came from. Also, if you have made, so what the act does for data controllers is, you may have some people who feel, say, yeah, every month I go make a data subject request just because I can. The act does put limitations on how often somebody can do data subject access requests. So the controller does have the right to refuse a request if they see that it is coming from a person who just made a similar request. So you have that. All right. So moving on. So here are some of the offenses and fines associated with them. Now, some of these fines were modified since the time I had done this presentation, but it gives you a general idea of the kinds of fines. So if you fail to provide free of charge particulars requested in writing by any person within 30 days, you can be fined up to $1 million. If you don't register and you're processing info, you can get fined up to $2 million or 2 to 5 years in jail. If you carry out processing without providing registration particulars, $5 million, 5 years in jail. You get the idea. There are consequences if you're not in compliance, but believe it or not, these are not the biggest ones. See here, if you fail to comply with an enforcement or assessment notice, $500,000 fine and so on. I think the biggest one is this last one. And this one, whole heap of consternation and argument and reign in Parliament and so on about it. Where a body corporate commits an offense within the ambit of the data protection legislation, up to 10% of the annual gross income is your fine. Now, when you think about 10% of the annual gross income of some companies, that fine can put them out of business. Which is why it is important to understand the ramifications of not being in compliance and put that into perspective when the investment you have to make to become compliant is contemplated. Because that investment may be less than 10% of your annual gross income, but then it now becomes a no-brainer as to why you need to make it. Because if you do not do that, this is what may befall. Before I move on, I see some questions in the chat. There are several companies that ask for IDs, such as driver's license, which is the TRN. Actually, it's not, but a lot of people don't know the difference between the two. However, there is now and has always been the risk of identity theft. Yes, as often as as often the information is written in a book. A better option might be to use control number on the back. Yeah, the control number is actually driver's license, but it's not the TRN. So here's the thing. You're absolutely right. But here's the thing now. the book that they're writing that stuff in, if that is not treated with properly, that entity is in breach of this legislation. Because remember, data is not digital only, manual as well. So this thing where you have books, writing stuff down, and you keep the book on a desk, sitting down in public view, and if you get up, left your desk, somebody just go up the book and take a picture with them smartphone, have data now about everybody in the book. Breach. These books cannot be left carelessly, nor can you simply employ that mechanism without employing a method of securing that book, right? So what is incumbent upon you as a data subject is when people ask you this info and you see them write it down in a book, watch what them do in the book. Because that book has data about you and a whole bunch of other people, and if it is not secured and treated with properly, that entity is not in compliance with the provisions of this law. Second question was, how can business protect themselves from a reputational risk where the person made a wrongful complaint on the company? Yes, okay. So here's the thing. The nature of how the complaint works is they're not making the complaint to the public. They're making the complaint to the Office of the Information Commissioner. Now, within the regulations, which will be promulgated soon, the regulations will speak to how the complaint is made and how it has to be treated with, especially as it relates to things like reputational risk, because that was a concern with many other people who weighed in, the stakeholders weighed in on this aspect of things. So within the regulations, it will speak to how complaints have to be made, the privacy concerns and so on with it. What I will tell you though is, if a complaint was made and you know, the audit was done and breaches were found and so on, the Information Commissioner has discretion whether to make that information public, but also is subject to the Access to Information Act that allows persons or media to request that information, right? So to avoid the reputational damage which may ultimately happen, make sure you're in compliance. But also, as part of the mitigation of fallout, you actually have to have processes in place that demonstrate to your customers that even though this may have been discovered, we have taken steps to treat with this, right? And that also includes a communications action plan for when breaches occur. And a lot of companies do not have these. I actually did an assessment and kind of damage control for a company. And when I asked them about that, they had nothing in place from a standpoint of communications. There are no communications plan for when a breach occurred. All of these things now are going to become part of your internal operations and processes, because when these things occur, not if, when they occur, you have to have things in place to you know, communicate and mitigate, right? Right.
There's a question before you run along.
Yeah.
In terms of the audit, who funds the audit? Who would pay the cost for the audit?
So the audit is the responsibility of the Information Commissioner.
Okay.
So they bear that cost because they're a funded agency. However, it's my understanding that obviously if breaches are discovered, then the controller who is being audited may have some, you know, cost to bear.
Okay.
Does that answer the question there?
The last one, in terms of, as you put it off the board, I was going to ask about the commission, the charges. Right, good, that one. The point we say is that commissioner or commissioner staff or agent of the commissioner who knowingly or recklessly disclose the information, how will we prove whether it was knowingly or recklessly disclosed? How will we improve that? That has to go to court?
So there are a number of ways that can be treated with, but that's a very good question. But what this was meant to do was speak to events that happen real time or events that happen with people who used to work for the commissioner's office, who go out the road, go tell media and all of these things, right? Because again, one of the things, and this will be covered in the regulation, one of the things that must not be done, and especially in consideration of reputational damage, is that no person within the commissioner's office should be sharing information that they receive. This provides the commissioner's office the ability to prosecute that person. They will have to conduct their own investigation. But if it is that you as a business discover that the information was disclosed by somebody from the commissioner's office, yes, you can take that one to court.
Okay.
You can take that to court, yes.
Thanks.
Mm-hmm. And here's the thing. My understanding is the penalty is not brought against the office of the commissioner, it's brought against the individual that works in the office. So, all right. So let's now wrap it up with the impact that this will have on your business. So a number of things that you now have to contemplate. How you're using the data, how you're securing the data, how you're controlling access to the data, how you will become accountable to the public and the Information Commissioner Office, how you will make sure that data is accurate, providing the ability for data subjects to verify accuracy of data, all the steps that you must put in place to demonstrate why you're collecting the info and how it is being used, to demonstrate that you're using it within fairness and lawfulness, how you demonstrate, that you have the different safeguards in place to protect all of this stuff. These are now the things that you have to contemplate and look at as a business to be compliant. Now, I tend to put these requirements into two areas: the policy and legal component and the technical component, because most times you may have entities come in and they assess the risk from a legal perspective, which is one way, but that is inextricably tied to technical measures that you must adopt in order to comply, because a lot of the technology you use is what manages this data that you're in custody of, right? So what that means is now you have to know the data that you collect, categorize it, understand why you have it, understand the risks of having it, establish a program to manage it, review all of your contracts with people who you deal with, that you share information with. And then now you have to, in a more religious way, look to engage a data protection officer, data protection officer service. You have to conduct impact assessments because the law now requires that you do so. You need to now conduct technology assessments. This is where companies like LAN Integrators, myself, many of the technology companies, there are a couple of us that do these assessments to show where you need to tighten up to be compliant. You have to create new policies internally. You have to implement new measures for security, how you handle data. Like I said, can't have the book sitting down willy-nilly on the desk with people information. One of the more recent clients that I have, and Robert is familiar with this one, you know, when I went and did an assessment for them, their internet connectivity, their flow and digital routers are on the receptionist desk at the front desk, which people walk past. And I say, well, yeah, that can't happen, you know, because what that does is allow me direct access to your network, right? I'm gonna say, yeah, but nobody can really do that. I said, no, they can, because all I have to do is lift up the bottom of the box, see what the network access information is, and I'm good. That I just have to wait on somebody to get up from them desk. Or I could be the auxiliary staff who nobody pays attention to while they're mapping the floor, and then just come, lift up all of that, get the info, and suddenly have access to your network. Yeah. Now, if I'm a motivated, nefarious actor, that's what I'll do, right? You can't leave sensitive information in folders lying around in reach of public. And again, I, you know, simulated this for somebody where I walked into their office, nonchalantly took some sensitive information off of a desk and walked into their office, showed them, and they were like, well, how did you get it? I said, yeah, it was just sitting down in this other office, unguarded. So all of these things now you have to change, because if that happens, you are now out of compliance. So you see, like medical offices and hospitals and so on, major impact for them, right? And of course, you will now have to make your employees more aware. You have to educate them. To get more into this, when you engage the data protection officers, they are there to ensure that you're in compliance, inform you of your obligations, and ensure that you're in compliance. A very important component of this. You can't do it yourself. You need people who actually understand how and what is required for compliance. You also need that individual or service, and here's a question about monitoring, to do the monitoring for you, right? Because you can't do it yourself, right? So what that means now is that you have a new component to your business, which is the data protection officer or officer service. And that person or entities who you rely on to advise you as to what you must do to be compliant. That is your liaison between your company as a controller and the information commissioner. You have to do risk assessments, and those risk assessments, which have to be submitted yearly, demonstrate compliance with the law, but it also tells you where you need to tighten up to be in compliance. It also helps to, you know, create a culture of data protection by design within your organization, because now what you're forced to do is every new project that you go on, an immediate consideration is, okay, data protection act and compliance. A lot of times we go into projects and we don't consider these things. No, it will create a culture of data protection by design. You also have to conduct technology assessments, review your hardware, your devices, and, you know, device security and so on, because all of these are touch points that could facilitate breaches and non-compliance. You have to review your networks. You have to review all the systems and software that you use. Are they in the cloud? Are they local? If they're local in your office, how are they protected? If they're on the cloud, are they in a jurisdiction, or does that company conform to data protection laws similar to the ones we have? How is that data being treated with, and what are the contractual arrangements between you and them? You have to now create new policies and controls. Controls for notification, controls for your contracts, controls for how you're backing up and treating with data, the retention policies, how, you know, your desktops, laptops, tablets, and all devices are treated with, and all of that, because all of these things at some point in time or another are part of a collection, use, storage, or disclosure exercise of data that you have in your possession. So what you need to now look at is the new policies and controls that you must implement in order to be compliant at the various levels. All right. In order to do that, you kind of have to know all the data that you have, categorize the data, determine how you're going to respond to the different requests that will come in either from a data subject or information commissioner, formulate a plan for communicating, data breaches, which you must do by law now. Determine how you treat with data that you either archive or have to delete. Review and revise your backup and data retention policies. And one thing that is often overlooked, there are very few companies that I've seen in Jamaica that actually do this, implement data loss prevention and protection systems and policies. This one is overlooked quite a bit. And what that is to ensure that whenever data exists in your custody, you know exactly what is happening to it. So this thing where, you have information in network, somebody put a jump drive in the computer, copy it off, walk out the door with it, and you don't know. That represents a breach and non-compliance to Data Protection Act. So you must know what happens to every piece of information or data, whether electronically or hard copy in your organization. You have to implement more robust data handling measures. Who is in custody of it? How you ensure that as it moves between environments, people, and so on, that it is secure. What do you do if somebody comes and says, I don't want to have my data anymore? How do you treat with that? What processes do you have in place to ensure that? One, you can delete the info, but then demonstrate that you properly deleted the info if the person says, well, I don't think they've deleted my info, I wanted to go audit them, right? So, and how do you ensure that when people provide you the info that they gave the right consent, you may have to have new clauses in your service agreements or contractual agreements to ensure that the info they share with you and how you treat with it is in compliance with the regulation. So also, and this is more from a technical standpoint, securing the information, encrypting data that is stored at rest or as it moves between different areas, ensuring that you deploy firewalls, intrusion detection systems, network monitoring systems and all of that, because again, you have to have complete eyes on everything that's happening in your environment so that you know when or if breaches occur, right? You have to protect all the devices, mobile phone to server, regardless of where it exists. So all of these things are considerations that you have to make and ensure that they are functioning in concert so that you maintain compliance with the legislation. And finally, we have, the most important, which is why I saved it for last, employee awareness, education, and training. Why? The single largest cause for data breaches is the employee, for a variety of reasons. And I think that is your biggest choke point, so to speak, when it comes to maintaining compliance. And that's why I highlight focusing on behavior, not only knowledge, because you can train employees to be aware of the fact that the law exists, but if they don't have a culture of functioning a particular way, then you can fall into breach or out of compliance really quickly. So it's something that is important for you to do, which is to focus on behavioral things, and you do that through exercises. So where you would do, data subject access request exercises. Simulate what would happen, how you would do it. Is everything in place? Impact assessment. You need to do all of these things and let employees get used to the norm of this kind of stuff happening. Another important thing is security awareness training. So something as simple as letting employees know how to function when reading an email, not to click on certain links, because by clicking on that link, somebody now gets access to the network, or somebody can now implement ransomware on your network, which puts your data in breach, which then takes you out of compliance with the law. All of these things become priority items now for compliance. So if you did feel, say, you could get around it for a little while, the legislation has now put the onus back on the data controllers to ensure that all aspects, both legal and technical, are in place to treat with my data properly. Now, bear in mind, when you're thinking about this, you may sit back as management and say, boy, this thing I mash up business and this is onerous. Consider as well that your data is stored by other companies and you would want them to treat with it properly as well. So it's, again, symbiotic relationship that everybody is invested in to ensure that data, both yours and that of your customers, because invariably you're a customer all the time too, is treated with in an appropriate way. And I think that's the 2-hour version of the presentation. Went a little bit over time, but I really hope that the information provided was useful, you know, to kind of help, you know, everyone understand, you know, the far-reaching nature of this legislation and some of the things that you have to do. And one thing I kind of want to leave you with is, again, you don't have to do all of this by yourself. There are companies out there, this is why LAN Integrators is putting this kind of stuff on, that can help you to get to where you need to get to in compliance. There is no one entity that will do it all for you. But what you want to ensure is that all aspects of your business are assessed and brought up to speed for compliance. You have just over a year, if you haven't started already, to do so. The good news is there are companies and businesses, 876 Solutions being one of them, Design Privacy, LAN Integrators, T-Tech, SimTech, a bunch of companies that have geared themselves to providing this service for you, to provide guidance as to how you can become compliant and maintain compliance over a period of time. Sylvia, Robert, that's, I think, my...
Trevor.
Yes.
I want to commend you for an excellent presentation. But you know, you have to do a part 2 when the regulation is in place, so you can have a companion document to work with. So while you're telling us about the act, you're tying it with the regulation, say the act says so, and hear how it is to be applied through the regulation. So you have a part 2, Trevor.
Yeah, no doubt. And the thing about the regulations, the regulation has to go through the same exercise that the act went through. So the regulations will be drafted. There will be public consultation on the regulation. I always encourage people to participate, so that you will see what is going to be the enforcement mechanism for the law that exists. So, I mean, and that is something I'm constantly close to. I speak with the information commissioner from time to time on that, and she has also solicited a group of us to you know, help with that. So yes, when the time comes, most definitely I will do that.
And we'll let you know as we go on. And there are further other things that we'll be posting that will be linked to this, that would aid the customers and you to be both aware and in getting implementation way forward. So what we have to start doing now with your customers is now starting to make schedules over the next couple of months to when we have to come in and start going through and assisting you in doing these audits working on the pricing on the audits and the costing of equipment, because some of you are going to have to upgrade some of the equipment you have, both for security issues and for breaches coming in, because as you've noticed, the pandemic brought a lot of us into the digital forum, and that has both good and bad implications. The good side of it is that yes, a lot of things get done easier, but it carries crime to the digital level now, which people now can hack you without seeing you. And it is on the increase in Jamaica now. Hacking, the black hackers are really out there. Hitting. So a number of our customers, infrastructure upgrades to your firewalls, security issues, how we implement certain things, where things are put, are going to have to be done. And we will work out in assisting you in getting a lot of this sorted out as we get to be compliant in the digital world coming forward. Because it's not only going to help you in the Data Protection Act, it's going to also help you in the security of your business itself. Because I don't know if you folks have been following, a lot have been happening, that has been happening even in the big banks, which are spending quite a bit on security, and yet still there have been breaches in their systems, some reported, some not reported. That it is going to come a time when the weakest link is going to be the one that they attack. So a lot of our customers now who think, "Boy, my place is too small, I don't necessarily have to worry about this." They have started to hit some small places with ransomware now, which people have not reported, but have had to pay some decent sums of money to get back their data or have access to their information. And this is why backups will become important. This is why how your access to the cloud will become important. This is why what we call putting in fault tolerance to your system will become important. And if you let us use a hairdressing kind of thing. Someone starting a small hairdressing parlor in which they have built up their clientele and have their database, who they send out their things to for appointments and so. Just think what would happen if their calendar schedule was to block or hit for a day, or where they couldn't have access to see who the clients that they should get in touch with, who should be coming in on their calendar, how that would affect their business. So, it's not something that we look on as this is a big man or a big business scenario. Your small business, some of our small business can be impacted by a lot of what's happening in the digital world now. So, we'll have to work together and put a formalized way to have this put in place and a plan. Some of it will not happen in an instant, but it may take time to have it put into place as you budget and structure your systems to become compliant over the next year. But we'll be here to work along with you to have this being done and work.
And something I kind of wanted to say, just in concert with what you were saying, Robert, many small companies don't feel that they're targets. But here's the thing, and speaking from a cybersecurity standpoint, small companies have very big clients, and the amount of data you're in custody of is oftentimes a lot bigger than the size of your company. So the size of you could have 5 people, but you're in custody of data of the magnitude that banks have. That makes you a target. And because small companies have big customers, and the big customers may have all the security measures in place, but the small companies they do business do not. That acts as the backdoor for hackers and threat actors, because they know that once they can get access through a low-level unsecure component of that chain, then they can eventually get to the big ones. So you'll find that even though some big entities get targeted, it is the small ones that don't invest as much or are less careless or more careless in protecting things that get targeted. They're easier targets. Hackers are notoriously lazy, but that is why this is important. That is why laws like this are important, because you now have to have a comprehensive and cohesive approach to protection of data. All right. Oh, cool. So once again, thank you everybody for indulging me. I mean, I know sometimes this legal stuff gets very boring. because it's a lot of words, but I hope I was able to condense it and distill it in a more understandable way. All right.
Thanks, Trevor and the team. Thanks.
Trevor, if I may, excellent presentation. Just one quick question for me. I know in the US, on the matter of compensation, if there are breaches, you can have class action suits. Does the law make any kind of provision for that, where, let's say, if your data was breached, you could file a class action suit against the company that would have breached or allowed your data to be breached?
Right. So
for that?
yeah, man. In fact, that existed even before the act, but the act now provides even more clarity. So in conjunction with the Constitution and the Charter of Rights, you always had that option. But what the data protection law now does is make it even more clear as to, okay, because let me clarify. Before the Data Protection Act, there was nothing that said what a business must do to keep my information safe. Generally, the Constitution and Charter rights spoke to my right to privacy, including data privacy, right? So if I launch a class action lawsuit around the fact that my privacy was violated based on data being shared and so on, what would be challenged was, well, there's nothing that speaks to how we should treat it. So you could launch a suit. The outcome may not be as serious as what can prevail now, because now there is something that says this is what you must do when you're in custody of people's data. So it is now very prescriptive, and if you now do a class action suit, all of the information as to what ought to have been done is there in law. And it will be very difficult for violators to skirt around the fact that, well, I didn't know what I was supposed to do to protect your privacy as stated in the Constitution or the Charter of Rights. Now there is, and for the first time, there is something that protects the citizens' data. So yes, class action lawsuits now would have greater impact because of the data protection legislation, because it prescribes in a lot of detail what ought to be done to protect my data.
Thanks, man.
Right. In wrapping up, I want to thank all of you who had come on to join us today. We're going to try and get out the recording of the session to those who were not able to make it, and for you guys to probably go over. I want to thank Trevor, our presenter, for again doing a good job, and you'll be hearing from him again on other topics as we go along in our series of informing you on the digital transformation process in which Jamaica is going through, and all our customers and companies and people have to put things into place to make life a little easier, but there are challenges in making it easier. I want to thank Sylvia for putting it together and getting it out to our customers.
There's a survey too. Remember the survey?
There's a survey that I'm going to want you guys to fill out and send in. And we may actually, because I'm getting a lot of WhatsApp messages that came to me during the thing, that there are some people who weren't able to join who would love to see it again. Well, we'll send out the recording, see if it's fine, but I may ask Trevor again to see for those who did not make it, if in the survey they want us to do it again at another time, to see if we probably can just have this in some time in the future to catch those who were not able to make it today. Again, thank you very much all. We'll be in touch, fill out the survey, and we will start creating some schedules with you guys working along on when we can start this process to get you compliant. If there are any more questions, you can ask quickly now, or I'll bid you farewell and enjoy the rest of your day.
All right. Thanks, Robert. Thanks, Trevor. Thanks, everyone. Excellent presentation.
Thanks, everyone.
Thank you.
Most welcome.